Hello and welcome. Very excited to be the first panel for our symposium this year. And I'm particularly excited about our panelists. So as Joshua mentioned, this panel is really about the pharmaceutical industry, in particular how well this antitrust paradigm fits the pharmaceutical industry. Not because antitrust and the pharmaceutical patents and other exclusivities that we see in the pharmaceutical industry are necessarily the only conflicts that we see between antitrust and IP, but because the pharmaceutical industry is in so many ways unique. This idea of using anti-competitive law to address a lot of what are perceived to be abuses in the pharmaceutical industry is somewhat of an odd fit, right? That we don't necessarily have a competitive industry within the pharmaceuticals, and that to the extent we have generics and follow-on biologics entering the market, they're often required by the FDA to copy the reference drugs and the originator drugs. And so how this interplays with the kind of antitrust theory that we often see driving a lot of the proposed legislation and already enacted legislation in this area. So just quickly to introduce our panel, I'm very happy to say that we have Professor Lee Branstetter, who is a professor of economics and public policy at Carnegie Mellon University, Heinz College of Information Systems and Public Policy. And then next to him, we have Professor Greg Dolin, who is at the University of Baltimore School of Law. He's also a scholar here with C-IP2, and most recently finished a stint as a Supreme Court Justice in Palau, which I think is quite interesting. And then next to him, we have David Korn, who's the Vice President of Intellectual Property and Law with the Farmer Trade Association. And then we have Kevin McDonald, who is Partner Emeritus from Jones Day in Washington, D.C. So why don't we have David lead us off?
Thanks, Emily. So for those of you not familiar with PhRMA, we're the Pharmaceutical Research and Manufacturers of America. We're a trade association that represents leading biopharmaceutical research and manufacturing companies. We advocate on behalf of the industry and our members on policy issues that support innovation in biopharmaceuticals, including both IP and antitrust issues. So this panel is focused on policy issues concerning biopharmaceuticals, and we're a research-intensive industry, as you heard, one of the most research-intensive. But there are unique aspects of our industry that are relevant for this panel discussion on antitrust. So I'm going to highlight important aspects of the biopharmaceutical R&D process, as well as how generic and biosimilar medicines fit into the landscape, as mentioned by Emily. So the drug development process begins with basic science research, and although a portion of this can be financed by NIH and include a variety of academic and small academic institutions and small biotech companies, without the investment and scientific expertise of the biopharmaceutical industry, the knowledge resulting from the basic science research would generate many ideas, but very few new medicines. So development of biopharmaceuticals is lengthy, costly, and risky, and is why IP is such an important incentive. And if you look at it from the left to the right on here, companies test many potential compounds, and the failure rate is very high. For each approved medicine, thousands of potential medicines could have been considered. And after discovery of a potential compound, you need to consider whether it actually has the sought-after activity, whether it's safe and can be administered in a useful form for patients. So companies test first in labs and animals and seek permission from FDA to test it in humans. Then clinical testing occurs in different phases, like the research you heard about in the context of the development of COVID-19 treatments and vaccines. These range from small phase 1 testing in a small group to test safety, to phase 3 safety and efficacy studies that can involve thousands of patients at different sites. And at each phase, the potential compounds may and often do fail. About 1 out of every 10 candidates or so that make it into clinical trials are approved by FDA. If clinical trials are successful, a company can submit a new drug application, or NDA, for drugs, or a biologics license application, or BLA, for biologics. FDA then reviews the data, and if it determines the medicine is safe and effective for particular uses, then it can be approved for the market. Overall, it takes 10 to 15 years to go from identifying a compound to FDA approval, and $2.6 billion on average when you factor in the cost of the failures. And even then, only 2 in 10 of the medicines that hit the market recoup the average investment in new medicines. So since 2000, pharma member companies have invested more than $1 trillion in researching and developing new medicines, with more than $102 billion in 2021 alone. IP and the potential for recovering the cost if a product is successful can allow companies to move forward with such long-term risky investments. And R&D and innovation doesn't stop just with an initial FDA approval of a medicine. Post-approval R&D can include study in new diseases, new improved ways of delivering the drug that can increase safety, improve effectiveness, and make it more convenient for patients, and improve patient adherence and outcomes in taking their medicines. Strong and reliable patent protections are a critical part of fostering investment, both in the process necessary to get to the initial FDA approval, but also for these innovations that occur after FDA approval. As this slide shows, at a high level, patents can be granted on different aspects of a medicine that can be invented over time. For example, they can be invented on the drug substance itself or active ingredient, on dosage forms for delivering the drug to patients in different ways, on ways to treat patients, on ways to use it for additional diseases, on manufacturing processes. And one of the unique aspects of the biopharmaceutical industry is what happens at the end of patent protection. Essentially, especially for small molecules, the system encourages copying, as Emily flagged. So for generic drugs, there's the Hatch-Waxman Act. Now, the formal name of this is the Drug Price Competition and Patent Term Restoration Act of 1984. Sometimes you hear about one or both sides, but there's an and. And it was compromise legislation in which there are provisions maintaining incentives for innovation and provisions to speed up access to lower-cost generic copies by creating a generic approval pathway. Now, I mentioned the timeline for developing a new medicine and the data generated and submitted to FDA. Under Hatch-Waxman, a generic does not redo all of the safety and effectiveness studies done by the innovator and shown on the prior slide. Rather, it's approved on the basis of demonstrating that it has the same active ingredient and is absorbed to the same rate and extent, so is bioequivalent. And it relies on FDA's conclusion that the safety and effectiveness of the innovator's drug. Now, as the generic benefits from FDA's finding on the innovator product, Congress provided data protection, or data exclusivity. This is implemented as a time period before which generics cannot apply or be approved, relying on FDA's finding that the innovator's drug was approved on the basis of that data. For new chemical entities and small molecules, this is 5 years, barring submission of the abbreviated application. It can be 4 years with a patent challenge that I'll describe. But for changes to an approved medicine that require clinical studies, like a new dosage form, there could be 3 years of exclusivity during which a generic could not be approved for that specific change to the drug. Now, Congress also addressed patents, which are separate from data protection. As the name indicates, Congress provided for patent term restoration. This is a limited restoration of part of the term of one patent lost due to the clinical trial and FDA approval processes. It provided that generics can do their R&D without being liable for infringement. And in general, it created a structure so that generics do not enter the market prior to patent expiration unless they show the patent is invalid or not infringed in court, with some limited exceptions. There's a specific procedure with generic certifications to patents listed in FDA's Orange Book publication. If a generic seeks to enter the market prior to patent expiration, it can make a paragraph 4 certification of invalidity or non-infringement, and there could be litigation under a special section of the Patent Act that creates a cause of action for infringement based on the filing of the generic application with an intent to market before patent expiration. Such litigation is filed before there's an infringing product on the market, so before there were damages. And Congress also provided an incentive for generics to challenge innovator patents through this mechanism, 180 days of exclusivity for the first generic filer against the later filed generic applicant. The net result of this is a system where there are robust challenges to innovator patents by generic companies as soon as they're permitted, with sometimes more than 20 companies challenging patents on a product. Significantly, 90% of prescriptions for drugs are filled with generics. Now, biologics are more complex products, and Congress created in the 2010 Biologics Price Competition and Innovation Act a framework that balances access to biosimilars and promoting continued innovation. Given the complexity of biologics and the inability to show that a third-party product is identical to the reference product, the BPCIA provided for approval of biosimilars where the product is highly similar to the reference product and without any clinically meaningful differences. Now, a biosimilar is not substitutable like a generic, but if a sponsor demonstrates that its product can produce the same clinical result in any given patient, and the risks of switching or alternating between the products don't exceed the risks of just using the reference product, it can be approved as interchangeable with the reference product and then substituted under state law. Now, Congress provided a different mechanism for resolution of patent disputes than in Hatch-Waxman, given the nature of biologics. It set up a process for confidential exchange of information on the proposed biosimilar product and patents relevant to it, as well as litigation prior to approval of the biosimilar. This is known colloquially as the patent dance. And as with small molecule drugs, there's also a patent infringement exception for developing biosimilars. To preserve the incentives for innovative biologics, Congress also provided for reference product exclusivity, under which a biosimilar cannot be approved for 12 years after first licensure of the innovator biologic, although it can submit its application after 4 years. Now, Hatch-Waxman and BPCIA govern the timeline for entry of generic and biosimilar products. Some policymakers believe that there have been anti-competitive fact situations in the context of generics or biosimilars, and they've made proposals to utilize antitrust law to address them. One area is so-called product hopping. Legislation is pending that would create a presumption of anti-competitive effect if a company creates a follow-on version of its medicine and then takes certain steps with respect to the prior version. In general, it defines a so-called hard switch for where a company no longer sells the prior version, and a so-called soft switch in which the company still sells the original version but takes steps to disadvantage the prior version. It's not clear why legislation is needed given the FTC's existing authorities. Moreover, it could put an antitrust cloud over post-approval research and development of new versions of medicines for patients. Another area is patent settlements. I mentioned that generics and biosimilars can develop their product without infringing patents, and both Hatch-Waxman and the BPCIA involve litigation prior to the marketing of an infringing product. As such, the litigation is different than for some other types of products, and settlements can also be different. Settlements can lead to generic or biosimilar entry prior to patent expiration, but the FTC and others have asserted that innovators pay to delay that generic or biosimilar launch. The Supreme Court provided in FTC versus Activists a framework for analyzing cases. However, these bills have been introduced in Congress that would create a presumption of anti-competitive effect and essentially put a thumb on the scale for the FTC if they were adopted. California also passed legislation that creates a presumption of anti-competitive effect, and other states have introduced patent settlement legislation. This seems like an area that, if it were going to be addressed, would not be appropriate for states to engage in. And Kevin will address the patent settlement issue in more detail. Finally, since the planning of this conference, there's been a new development that should also be acknowledged: the passage of the Inflation Reduction Act. We've heard many things about it, including that there is negotiation of drug prices in Medicare. However, given its structure, it operates more as a price-setting mechanism by the government, a government price control. The legislation does not directly change IP law, but the timing of the price control mechanism is before the time needed for generics and biosimilars to come to market under the previously discussed statutes, particularly for generics. As such, it undermines incentives for innovation and balances struck under Hatch-Waxman and the BPCIA. It also takes place regardless whether there are existing patents or exclusivities. Finally, and perhaps most importantly, the process takes place before many critical post-approval improvements can be realized, which is important in fields like oncology, and creates a disincentive for such research. I think policymakers should recognize that the landscape of incentives for innovation is impacted by the IRA, the Inflation Reduction Act, and consider that when evaluating antitrust or other policy changes that can impact incentives for innovation. Thank you.
Yeah. All right. Well, I want to express my profound gratitude to David Korn, my predecessor on this panel, because he's done an excellent job of explaining with a remarkable economy of words how the pharmaceutical innovation system is regulated under current law. He's done a great job of describing recent and prospective future challenges to this system. So there's a lot of ground that I don't have to cover as a consequence, okay? What I want to talk about, though, is how the Hatch-Waxman system, right, and to a much lesser extent, you know, the biologics regulatory system, evolved between the late 1990s and the early 2010s, right? Because what David didn't say, I mean, he certainly knows this very well, is that that system has altered in some subtle and non-subtle ways. There were important legal decisions, policy changes, and legislation that tweaked the parameters of Hatch-Waxman in ways that made it significantly easier for generic competition to come into pharmaceutical markets. And what I want to talk about is the evidentiary record on what happened to the drug development activities of branded pharmaceutical companies as these changes were made, right, and as they started to face earlier and more significant generic competition. Because at the end of this talk, you know, David suggested that even subtle changes to our current regulatory framework could have significant impact on pharmaceutical innovation. And what I want to provide, based on the recent history of the evolution of this system, is strong evidence that that is in fact the case, right? That changes to the system can have pretty significant impacts on where and how pharmaceutical companies develop new drugs. All right. Hopefully, for most of the people in the audience, this is not a controversial claim. That pharmaceutical innovation is really important. It's very impactful on human welfare. Here are some bullets based on research by economists that suggest just how important this is. And of course, you know, for all of us who are living through the pandemic, we've had a recent reminder of just how significant timely pharmaceutical innovation can be. What's also true is that while the United States is just one country, this pharmaceutical marketplace accounts for a disproportionate share of the global pharma industry's profits from new drug development. And so changes in the system can have an impact on the incentives for innovation and the nature of innovation that radiate far beyond our borders. All right, so you know, David again did a masterful job of describing the Hatch-Waxman system, right? And that system was introduced into legislation in 1984. Between 1984 and the mid to late 1990s, there was certainly an acceleration of generic competition into the U.S. pharmaceutical marketplace. But between the late 1990s and the early 2010s, there were several other decisions that intensified this competition even further, allowed it to begin even earlier. And I'm not going to go into the details because I suspect that in the audience there are many people who know about these court cases to a much greater depth than I do. And there may also be people in the audience who know about the FDA policy shifts that allowed generic entry to start earlier in the product life cycle and become more intense. And there were also acts of Congress, including the Medicare Act of 2003, that similarly facilitated and accelerated generic competition, right? As a consequence of all this, by the end of my data window, right, which is the early to mid 2010s, generics accounted for a very large majority of prescription drug sales, and now it's up to about 90%, I think David just said. Over this period, generic entry was occurring at a steadily earlier point in the product life cycle. And I've done some research to suggest that this actually had a substantial effect of shifting surplus from the producers of these branded drugs downstream to the consumers, right? And presumably some of this surplus shift went to actual patients. But as I pointed out in a previous paper, there are lots of agents involved in these transactions: pharmacies, drug wholesalers, insurance companies. And even with the rich data at the disposal of my research team, which I'll talk about and brag about in a minute, it's very hard actually to determine what fraction of this surplus shift actually benefits patients as opposed to these other actors. But here's the question: how has all this impacted pharmaceutical innovation? Right? What we find is evidence of a pretty strong negative relationship between the increasing intensity of generic competition and early-stage pharmaceutical drug development, which I'll define in a moment. But to give you a sense of the magnitudes, a 10% increase in generic penetration, as we measure it, is associated with a decrease in the flow of early-stage innovations of about 6 to 7%. And for economists who study the impact of innovation policy on innovation, this is a very large, right, like almost an implausibly large number. Even if we restrict our purview just to pharmaceuticals that are the first in their class, right, that mean any meaningful test of innovativeness, that negative effect is still very strong. So it's statistically significant, but it's economically significant. And in my field of economics, whenever you find a statistical relationship like this, the norms of our profession require you to do everything in your power to destroy it, right, to try and make it go away, to demonstrate its robustness. So we spent literally years throwing everything we could think of at this statistical association, and we didn't make it go away. So this seems to be about as close as one gets in empirical economics to a fact. Now, what's also true is that within pharmaceutical markets, as generic competition becomes more intense, there's a shift from small molecule or chemistry-based innovation to large molecule or biologic-based innovation, right? So the impact of increasing generic competition affects the direction and also the nature of drug development activity. Now, we don't find evidence that the overall level of early-stage innovation is declining across the board, right? It's not that rising generic competition is depressing the overall level of innovative activity, but it is determining where and how it's done. And my co-authors and I worry that there's at least the possibility that in tweaking the parameters of our system, we've actually overdone a little bit, right? And so we've made it very easy for generic competition to emerge in the small molecule space. And by shifting so much innovative effort to the biologic space, we actually may be facing dramatically more expensive drugs later. All right. Those are the claims that I make in the paper, which has been circulated. So if I run out of time, or if you just want to spend the next few minutes thinking about something else, right, there's the reference that you have. What I'm going to do for the remaining balance of my time is to try and convince you that there's a strong evidentiary basis for these claims that I've just made. So this will require me to speak the devilish tongues of statistics and economics for a moment. I hope that's okay. How do we model innovation, right, which is the dependent variable that we're trying to predict here? We use a data set called pharma projects, and we use that data set to count the number of compounds in the preclinical or phase 1 stages of the drug development process. So Dave just gave you a very nice map of the drug development process. We're focused on the earlier stages of that. And we're also going to define a pharmaceutical marketplace as being an ATC 2-digit category, right? So lots of domains have a taxonomy of products. The pharmaceutical industry has a taxonomy of products, and we're focusing on the ATC 2-digit level of disaggregation. To give you a sense of what that is, we've given you some examples of ATC 2-digit drug categories in the central nervous system domain. Okay? And we're going to presume that drugs in this space compete with each other, at least to some extent. Okay, our key right-hand side variable is a measure of generic competition. This is based on the MIDAS data set, which is an incredibly rich data set. We're going to define our measure of generic competition as the sum of all generic sales in product market J at time t divided by the sum of generic sales and firm I's own branded sales in the same market J at time t. And to the extent that generic penetration does lower incentives for innovation, we would expect this variable to have a negative coefficient in our statistical analysis. Now, of course, innovation doesn't just depend on the level of generic competition firms face. It's also driven to some extent by the science foundation upon which pharmaceutical companies can build. So how in the world do we measure that? Let me take a deep breath, okay? We begin by using data from the NDTI database, which describes which drugs physicians prescribe for which diseases, right? So this is based on actual physician prescribing behavior, and it links drugs to the diseases that they're designed to cure or treat, right? That allows us to actually link the taxonomy of diseases with the taxonomy of drugs at a fairly disaggregated level. Right? We then take the top 5 keywords corresponding to each of these drug categories, and we retrieve publications, scientific publications, from this massive electronic database maintained by the NIH called PubMed, which is essentially a repository of medical science that goes back to the 1950s. It has a unique identifier for every article ever published in biomedical science. This amounts to 6.5 million journal articles. There's a one-to-many relationship from diseases to drugs. So we wind up with 20.9 million raw article counts. These articles have 345 million forward citations. We take all this, right? We link it to individual drugs, and we include it as our measure for scientific opportunity or technological opportunity in a drug domain. Okay. Now we face we face many, but a key inferential problem. And let me try and state the problem as best as I can in plain English. Okay? Here's the problem, right? We observe innovation dropping off, and we observe generic market share rising, right? What we want to assert is that it's the rise in generic market share that pushes innovation down. But of course, in some cases, a drug company could just start running out of new ideas and not be able to find any others. And so innovation falls, patents expire, that leads generic penetration to rise, but it's a decline in research productivity that drives the increase in generic penetration, not the rise in generic penetration that chokes off innovative effort. So what are we going to do about this? Right? Well, here's what we're going to try and do. Right? We're going to assume that firms' research productivity in a particular pharmaceutical domain is going to be correlated, at least to some extent, over time. So if I start becoming less productive in some domain today, I probably started becoming less productive in that domain yesterday too. So that's going to depress the number of measured drugs in my late stage pipeline. It's going to depress the number of products that I've introduced into the marketplace in that domain over the last few years. It will reduce my size. And we control for all this stuff and a lot of other stuff. And we still have this very strong negative relationship. It's a relationship that we can't make go away. I've already described to you the magnitudes. And when we measure whether or not the rise in generic penetration leads to a shift out of small molecule and into large molecule innovation, we see strong evidence that that's the case. Okay, I'm running short on time, so I won't try and decode this regression equation or the coefficient table for you. Let me instead jump to the bottom line, which is that this evidence suggests that increases in generic penetration generated by these subtle and not so subtle tweaks in the existing regulatory system have depressed innovation in those domains, right? Aggregate innovative activity has not declined. So what's happened is as generic penetration intensifies in some regions of the product space, pharmaceutical firms push their research efforts elsewhere. They also shift their research efforts out of small molecule or chemistry-based drugs and into large molecule or biologic-based drugs where competitive generic entry is just much harder for lots of technical reasons that David briefly alluded to. Is this a problem? That's a great question, right? And I have to concede that there is an interpretation of these results that suggests that our policymakers are doing a wonderful job of getting things absolutely right, right? In places where we've got lots of cheap generic drugs, the social benefit to additional innovation may be limited. Maybe you want to push the innovators to look elsewhere or to look for different kinds of drugs. But while that's a nice story, an equally plausible interpretation of what we're seeing is that we've actually overdone it, right? We've made competitive generic entry a little too easy on the small molecule side. Firms are rationally responding by moving into a domain where the drugs are so complex that competitive generic entry is going to be harder, right? Even if there's further policy change to accelerate it. And this means that we could be getting more and cheaper drugs today, but our drugs could be more expensive tomorrow. And that could create an argument for a modest rebalancing that levels the playing field a little bit between biologics and generics. Okay, I did go a little bit over. Sorry about that, Emily. But I'll stop now and look forward to the Q&A afterwards.
Thank you.
Good afternoon. It certainly is a pleasure to be here. I'd like to make one comment on Emily's introduction of me as being with Jones Day Emeritus. It is, of course, a fancy name for retired, but as those professors in the audience undoubtedly know, emeritus is a Latin word that comes from actually two other Latin words. The first is ex, which means out of or away from. The second, meritus, which means ought to be. In any event, before I retired, I spent 37 plus years litigating antitrust cases at Jones Day, and I spent the last decade and a half almost exclusively representing pharmaceutical companies and dealing with the antitrust claims that are brought against them now. I'd like to begin with my answer to the question that this panel poses: does the antitrust approach fit the biopharmaceutical space? And I'm fairly confident that I have the correct answer because my answer is yes and no. Let's start with yes. Antitrust legal principles embrace IP rights. First of all, antitrust law respects property rights, including intellectual property rights. One of my favorite cases is from 1902, Beeman versus National Harrow, in which the Supreme Court said the most important fact in the antitrust claim brought against a patent license was the fact that the agreement concerns articles protected by letters patent, making it clear for well over 100 years that innovation is not only respected by the antitrust laws, but it's considered pro-competitive. And if you think about it, IP rights are often the only reason why a given agreement or enforcement exercise of IP rights are legal at all. If you think about a patent license, that's one party telling another party who is a potential competitor, you're going to compete this way in this part of the country only and with these products and at these prices. That would be considered, as many have pointed out, per se illegal market division, were it not for the fact that the patent gives you the right to control who uses that invention. Another antitrust principle is antitrust law does not protect unlawful competition. So if there's a claim that a generic or a drug maker or someone else was excluded from a market, there is, the question arises whether the excluded competition alleged would have been legal. In addition, the antitrust plaintiff has the burden to show that excluded competition would have been lawful. That's a principle which actually has survived the Supreme Court's activist case, which was mentioned by David. And finally, an important principle for our purposes is competitive changes made by other regulatory laws don't impose new antitrust duties. This is important given the Hatch-Waxman context in which we deal here and the many advantages that are given to generics. In a case called Trinco and another one called Linkline, the Supreme Court made clear that the fact that a different regulatory regime gives certain competitors in a market an advantage does not change what antitrust duties are. In those cases, it was communications law, which said that big networks like Verizon had to give access to their network to smaller competitors, and the plaintiffs alleged that they had failed to do that as the communication law provided. And the Supreme Court said, well, that's perhaps they violated communication laws and there's a remedy under those laws, but that doesn't change the antitrust duties, so we're not going to let you bring a treble damage action for antitrust in that regard. So legal principles, in my view, are not the problem. What the problem may be for IP is that antitrust enforcement policy does not embrace those rights. First, antitrust is a political catch-all remedy for bad business behavior. We can have some sympathy for the heads of the enforcement agencies who are dragged up on Capitol Hill and ask them why they haven't brought an antitrust claim against gasoline companies for charging high gas prices, or for virtually anybody who is participating in raising prices as a result of inflation caused by corporate greed. So they have to explain to them that in most of those cases, this is not a problem of the markets being constrained in their competitiveness. This is a market that's behaving exactly as you would expect. Second, as institutional plaintiffs, the FTC and the DOJ understandably want remedies under the antitrust law that would hold somebody liable to be broader. This is both applies to procedure, such as who would have the burden of proof on a given question, and subject of the substance of the liability, what kind of practices would be. It makes no sense for them to root for broader defenses and immunizations. Another thing that the enforcement agencies I've noticed over my years was they routinely mistake regulation for competition. That last point from the last slide, that they think that the purpose of every statute, not just the Sherman Act and not just the FTC Act, the purpose of every statute is to increase competition. So if something happens in the administration of those other statutes that they think reduces the leg up for example, they want to give to generics, then that reduces competition. Intellectual development antitrust comes primarily from the same agencies in the academy, which is quite often a good thing. We want studies, and we want speeches, and we want articles to be written by those who enforce the antitrust laws. But again, their institutional incentives are to promote their current agenda. One of the, and you'll see this as virtually every new administration comes in, there's a new merger guidelines statement issued. There's a new assessment of what Section 2 liability should be. And the next administration comes in and throws the last administration's efforts in the dustbin. And then we should note that enforcement agencies have the power to investigate away lawful conduct. And what I mean by this is that if you take the question of reverse payments as an example, in 2003, the FTC got Congress to add a provision to the Medicare Act that said that if you have a Hatch-Waxman patent settlement, you must file it with the FTC. The FTC has made clear that if you do engage in what they consider a reverse payment settlement, that they will investigate you and you'll pay millions of dollars defending yourself, and 8 years later, you might be vindicated in court. But I can tell you from experience that clients will not take that risk. Okay, so how would these principles apply? The legal principles I talked about in the case of reverse payments. We'll consider that example, the settlement of a Hatch-Waxman case. We know the antitrust law does not protect unlawful competition. Again, for well over 100 years, one of the early statements was, the public is not entitled to benefit from competition among infringers. We know the antitrust plaintiff has the burden to show that the competition would have been lawful. That has survived the activist case, I'm pleased to say. Now, that burden can't be carried in any sensible way by retrying the settled patent claim during the antitrust case. Go back and see, well, who would have won? This is what one court of appeals, the 11th Circuit, called the turducken problem. Turducken is a dish that I understand some, like the sportscaster John Madden used to love, where you stuff a chicken inside of a duck, and then you tuck the duck inside of a turkey, and you cook that. The court said, well, we can't be stuffing a patent trial inside of an antitrust trial. If the claim was colorable by the patent holder, the infringement claim was not frivolous, we already know either side might have won the patent case. So trying it now doesn't tell us anything we didn't know. The conclusion that brought the vast majority of courts to before the activist case was that to show the generic entry would be legal, a plaintiff must show that the infringement claim was objectively baseless. In other words, you're not just guessing that the generic would have won this patent case, you're saying the generic would have won every patent case because there's no good faith argument in favor of the claim. So that brings us, after 10 years of cases deciding things essentially that way, to activists, its challenges and its solution. When the FTC got its case to the Supreme Court, the challenge was to find a theory of competitive harm that ignored the patent. Now, the FTC said that the patent wouldn't have to be at issue because we can imagine a better settlement in which the generic entered sooner. Factually, that had one huge flaw, is that the generic charges much lower prices than the patentee for the drug. So if you extend the license, the generic gets a little bit more profit. The patentee loses a huge amount of profit. So if the two parties are close together and the generic says, I need another 6 months to get $20 million more in profit, the patentee says, well, that 6 months is going to cost me $100 million more. We are not going to have a settlement at all. So the Supreme Court and activists basically ignored the FTC's argument along that line and did not adopt that. The other thing the court had to do was find a way to get around the traditional patent settlement in which somebody has entered the market, infringed the patent, engaged in a huge amount of sales, and then there's a lawsuit. Say the plaintiff seeks $100 million in damages, and they settle the lawsuit for $30 million in damages. That obviously transfers $70 million worth of benefit discounted by the possibility of losing to the generic, and yet the Supreme Court said, well, we're not going to disturb any of those old settlements that have been going on for a century as well. So how did they meet that challenge? They said a settlement that contains a large and unexplained reverse payment, neither of those terms was ever defined for the lower courts, is anti-competitive because it retains for the patentee a right it would lose if it lost litigation and had to face a competitive market. Now, what that is essentially saying is there any risk of loss by the patent holder that's being avoided in the settlement is an anti-competitive effect. Well, all non-nuisance settlements in litigation compromise on the risk of loss. That's what a settlement is. Now, according to the court, it's an anti-competitive effect, but only if it goes one way, only the risk that the generic might win. They ignore the risk that the patentee might win, the patent holder might win, and therefore we'll avoid having an infringing drug in the market. And then, of course, they said, well, the traditional settlements, we don't have to worry about that because if you have a traditional considerations such as litigation costs or fair value of services, that won't be suspect. But of course, those two aspects are just a tiny part of the reason that people settle cases. They all settle them because of risk. But that still leaves the question of how are you going to get around the patent? What's the turducken point? What are we going to do about the patent merits? Well, in one breathtaking paragraph, Justice Breyer solved that problem. First, he said, it's normally not necessary to address the patent merits to answer the antitrust question. So really, exactly why is that true? Because the large payment would normally suggest that the patentee has serious doubts about the patent. Well, one immediately says that kind of depends on what you mean by large. And so Justice Breyer, in the very next sentence, says, well, except of course we recognize that if you had a particularly valuable patent, even a small risk of invalidity justifies a large payment. So assume that you thought you had a 90% chance of winning the patent case, and you have $1 billion drug. You know, what's 10% of $1 billion over the remaining life of the patent? That's a huge number in the hundreds of millions. But undeterred, Justice Breyer is nothing if not breezy. He says, be that as it may, payment likely seeks to prevent the risk of competition. Well, a risk that we have just recognized could be very, very small. But still undaunted, he proceeds in the next sentence. In a word, the payment size can provide a workable surrogate for a patent's weakness, except, of course, for, as we just recognized 2 boxes ago, it might not indicate weakness at all. It might indicate great strength. But that leads him back to the same conclusion he started with. Thus, there's no need for a detailed explanation of the patent merits. So what happens after activists, other than this paragraph being nominated for the Tautology Hall of Fame? We have activists in the lower courts. The courts were not happy about the amount of guidance they got from the Supreme Court. One said they were deliberately opaque about the parameters of these claims. And another that said the Chief Justice clearly saw the trouble this could cause, and these motions have certainly proven his concerns well-founded. The view espoused by the FTC and adopted by the majority has been subject to cogent criticism and citing Chief Justice Roberts' dissent in Activist. But the controlling precedent is what it is. Now that is a rare thing to read in an appellate opinion about a Supreme Court opinion. And the same court said, this vindicates the Chief Justice analogy. We cannot resolve this aspect of the case without considering the merits of the underlying patent dispute. So after Activist, what have we got? Turducken is on the menu. Patent trials within antitrust cases are plentiful. Experts on patent law are testifying as to who would have won. And I'm happy to say that one of those experts now being paid for such opinions is my sister, who just retired from the Federal Circuit Court of Appeals. Judge O'Malley, who I learned by attending this conference, is now on one of your boards. So I need to talk to her more often. We texted yesterday, but it was about Wordle, I think. Okay, two of the appeals court cases said not only invited but required the plaintiffs to prove that they could have won on the merits. The plaintiffs in those cases didn't think they had to prove that, so their evidence was insufficient. Other courts are using safe harbors for workarounds to activists. Judge Easterbrook in Humira, that was the patent thicket case that said what's wrong with owning a whole bunch of patents, has interpreted activists as saying, well, if you're going to allow that traditional settlement where the people compromise on the damages, I say that's an opportunity cost. So if I see anything in the compensation for the settlement that looks like an opportunity cost, that's not a payment, according to activists. And most recently, the Fifth Circuit did affirm the FTC in finding a settlement agreement illegal under the antitrust laws, and has actually sort of given a better settlement theory disguised as a less restrictive means test under the rule of reason, and I will spare you the details needed to explain that. I would just say as we proceed forward to make sense out of activists and some of the other claims that are coming forward, it's important to keep in mind that the institutional pressures on the antitrust enforcers will keep them trying to limit the powers of IP rights, and will keep them coming up with new antitrust theories. And so I think it's safe to say that the legal principles so far perhaps have not been enough. Only the Supreme Court can say that the legal principles are just as important as the policy principles. Thank you very much.
Thank you very much for having me here. It's definitely a pleasure to be back on a panel with some old friends and new ones, and it's also nice to go last because most everything has been said and I can just stand around and wave my hands and sound smart. I don't have a PowerPoint, I'd like everybody else, because although picture is indeed worth 1,000 words, us law professors simply happen to prefer the 1,000 words. And so that's what I'll be doing. And so I'll begin kind of where I begin in some sense with my first-year law students who come to, so I teach first-year law students, I teach this semester, I'm teaching torts. For one of my sections, I was literally their first professor they encountered in law school, and they come eager, bright-eyed, bushy-tailed, and they want to know, what's the law, what's the rule, and what I've been trying to teach for the last several weeks and throughout the semester is that I can teach you the rules, and I can do this probably in a couple of weeks, but the rules only exist because they're trying to actually implement some sort of policy goal that we have. They come in thinking like, okay, well, we have the rules, and then we figure out policy. I'm like, no, it's the other way around. We have some values, some policy that we think is important, and then we craft the rules to advance that policy. And so we can look at this IP antitrust paradigm and IP antitrust tension from the same perspective. And so what are the goals we're seeking to accomplish? Well, I guess it depends on where you are. So if you're kind of somewhere before 1970s, before 1980s, before Robert Bork's famous book, Antitrust Paradox, then the goal of antitrust law is really to protect and increase the participation of competitors. We're really focused on competitors, and therefore it makes some sense that we will have rules that will prohibit or punish conduct that disadvantages competitors. And if that's your starting point, if that's your policy, then there is an obvious clash with IP, because the whole point of IP is to eliminate competitors, right? So that's what exclusive right means. It means I can exclude others, right? But after Bork's book, and after kind of Judge Posner and Judge Easterbrook go on the bench in the 80s, and after Supreme Court sort of decides state oil versus con, we actually have a very different view of what antitrust is meant to do. We're no longer focused on competitors, we're kind of focused on competition, and even that is secondary, because instead we're focusing on consumer welfare. And in that sense, there is really no tension between antitrust and IP, because both IP and antitrust are seeking to promote consumer welfare. We don't actually care all that much for the inventor. And how do we know? Well, it's right there in Article 1, Section 8, Clause 8. It says, why do we have IP rights? Is to promote the progress of useful arts, or science, if we're talking about copyright. Right? So, as David early on said, right, it's all about, why is IP important to the pharmaceutical industry? It's not because it's nice to go around waving a piece of paper with a fancy red seal on it. It's because it's important to get drugs out into the world, right, and to protect that investment. Right? And again, to be honest, nobody cares about pharma companies and their billions of dollars, only except as insofar as they're getting stuff to consumers and making consumers better off. And so, from that perspective, both IP and antitrust actually tools to increase consumer welfare. And once that is recognized, right, the clash dissipates, at least somewhat, right? But that is not necessarily how especially antitrust enforcement agencies, how FTC is actually attempting to litigate these cases. So let me actually pick up where Kevin left off and talk about a little bit about Octavius. Right, so the key to Octavius was the agreement, right? It's not just a reverse payment. The court focused on reverse payment. Everybody kind of said, like, oh my God, like, you're bribing people to stay off the market, and that's terrible. But really, there was a key to Octavius that is almost often swept under the rug, without which it does seem very much sort of like a problem. And the key is that going into litigation, we don't actually know who is going to prevail. Is it going to be the branded manufacturer, patent holder, or is it going to be the generic? Now, of course, if generic wins, they get to enter the market really early. They get to put their product on at much lower cost. Consumers get the benefit of early cheaper product, let's say at year 3. Hypothetically, right, year 0 we start litigation, takes some time to resolve. At year 3, generic wins, consumer gets early entry, lower cost. Great. But what if generic loses, right? At that point, consumer doesn't get the generic entry until, let's say, hypothetically, year 7, right? Meaning from year 0 all the way through year 7, they'll have to end up paying high cost or high prices for the branded drug. And so what happens in reverse payment settlements is not just the payment, but in addition to the payment, the branded and the generic compromise say, okay, you don't get to enter at year 3, but you don't have to wait till year 7. You enter at year 5, right? So consumer basically is now guaranteed that they will pay lower cost at year 5. Sure, it's not as good as paying at year 3, but it's not as bad as paying it at year 7. And so because there's some uncertainty as who would win, this type of settlement is potentially consumer beneficial, right? So if the patent is indeed valid, but you still allow your competitor or generic to enter at year 5, consumer wins. Of course, if the patent is invalid, right, consumer loses because they could have entered year 3, but now they have to wait all the way until year 5. And that, again, as Kevin pointed out, that's the big unknown. And it's not uncommon for litigants to split, but it's also not uncommon for litigants to split the cost of the uncertainty. Supreme Court, however, as I think I've alluded to, focused mostly on the money aspect, viewing the large payment as presumptively anti-competitive, as was just illustrated in Justice Breyer's opinion. Now, before you start throwing things at me, there is some logic to it. It's not great logic, but there is some logic to saying, look, if you're willing to pay lots and lots of money, as that payment increases, right? And of course, we have to account for how valuable the patent is and how many years are left in the patent, but still, as the payment increases, it is some indication, not a perfect indication, but some indication about your worry about patent validity, or at least the likelihood that whatever generic is doing may not be infringing on this patent. And so money is potentially at least somewhat problematic, and at least somewhat potentially justifiable as taking a jaundiced eye to settlements involving money. But post-Actavis, so Actavis is 2013, kind of water under the bridge. It's been 9 years, and we kind of have to live in this in Justice Breyer's world, and we just live in it, right? But post-Actavis, number of scholars and FTC itself and some states, for example, California, have tried to go after other settlements, which are almost obviously consumer-centric and consumer beneficial. So one of those cases, and I actually had no idea that AbbVie is one of our sponsors, so I'm not, I'm not trying to kiss up to anyone. I did it while preparing, but one of those cases is AbbVie versus Teva. Teva is a generic manufacturer, and AbbVie is a brand name here. There was litigation about AbbVie's product called Androgel. It was in the Third Circuit. It's a testosterone it's a gel that is prescribed for people who have basically low testosterone. It's testosterone replacement therapy. Teva files its paragraph 4 certification. The usual Waxman process happens, right? And eventually they settle. And with not really a money exchange. Instead, what AbbVie says is that, look, you have to wait a little bit. You agreed to enter later than you may have otherwise entered. And what we'll also give you, we know that you already managed to get FDA approval to enter the market for a different product called Tricor, which is a cholesterol product, which also, by the way, we own a patent on. But we also know that for reasons unrelated to any of this lawsuit, reasons unrelated kind of to anything else, you are having trouble manufacturing Tricor. You're having trouble getting some other regulatory approval beyond the paragraph 4 stuff. So tell you what, says AbbVie. We will manufacture, basically we'll give you a bunch of our Tricor, right? So you don't have to manufacture, you don't have to kind of reinvent the wheel. We'll give you a bunch of our drugs. You can sell it under your name, thus basically reducing the cost of manufacturing. And that's kind of going to be your compensation. FTC gets very upset about this, right? They sue AbbVie. They allege that this was all sham litigation. They allege this was a reverse payment, anti-competitive reverse payment. But think about what the settlement does. Now consumers are guaranteed not just a potentially early entry for Androgel, but they're guaranteed that there will now be 2 manufacturers of Tricor. Not because of any sort of finagling or any sort of sham litigation, but because Teva simply was unable to manufacture Tricor. They had a legal right to do so. They had no technology. And AbbVie says, we'll give it to you. And we'll allow you to sell to consumers at lower price. And FTC thinks this is terrible. How can that be? How can that be terrible if consumers are getting lower price for both Androgel, perhaps with some delay, and Tricor right now? Right? Now, there are other, of course, attempts. There were other ways for companies settle, including cross-licensure, including, again, forgoing authorized generics, where, for example, a brand name company says, we will not enter the market by trying to undercut you, thus making your 180 exclusivity period less valuable. And FTC thinks all of this is terrible. And again, I think part of the problem is that it's 2 problems. One, that they're focused on competition, but also everybody's looking at the static effects. And sure, if you try to not enter, basically if you promise a generic company that you're not going to try to undercut their 180-day exclusivity period, the consumers, for that 180 days, when they could have been getting 3 versions of the drug, the branded, the authorized generic, and the non-authorized generic, right? For that 180 days, they might only get 2 versions of the drug. But by promising not to enter the market, you're making the challenge and future challenges more valuable, thus incentivizing future generic companies to challenge not just this drug, but other drugs as well. And you cannot look, and I think this was Professor Branstetter's point, that sure, cheaper drugs now, but at what cost down the line? We're winning 180 days battle, right? But are we losing the war? How am I doing on time?
You've got 3 minutes.
2 minutes, okay. So let me kind of finish. I had more to say, but let me finish with this. The biggest problem or the biggest question that anybody who does antitrust knows, the biggest question is really the market definition, right? Everyone who's ever done antitrust litigation or who's even studied antitrust in law school knows that the most important question is, what is the market? And the answer to that question affects evaluation of whether somebody is a monopolist or not. And in the patent world, similar question arises all the time, right? Basically, and especially in pharma world, what is substitutable? What is the market? What are consumers buying? But patents, as it turns out, are rarely monopolies. As the old saying goes, a patent is a reward for building a better mousetrap. But if you start pricing a mousetrap too high, I'm just going to go end up and buy a cat, right? So there's rarely situations where a patentee really is a monopolist, and there are no alternatives. There are some, especially for first drug in its entire class, right? If somebody comes up with an AIDS vaccine, for a while they'll in fact be a monopolist, right? But it's rare, right? If somebody starts pricing Advil too high, you're just going to go switch to Tylenol, right? And so, and again, it's something that is just lost to people who, like FTC, who are blindly focused just on antitrust and antitrust alone. Because of course, if you define the market by reference to a specific drug, saying, look, can I get Tylenol from somewhere else? Let's assume for a moment that Tylenol is on patent, right? Then the answer, of course not, right? But that is the very nature of IP. But if you define the market, what is the market for pain relievers, right? Or market for COVID vaccines, we now know you have Moderna or Pfizer. In fact, they're substitutable. Sure, Moderna is a monopolist for Moderna vaccine, but that does not have a monopolist in any meaningful sense, right? And FTC's view ultimately undermines the consumer-centric view of both IP and antitrust, because it focuses, again, on competitors. Can somebody produce the exact version of Moderna vaccine or exact version of Tylenol, as opposed to, can consumers get a bunch of similar products, not identical, but a bunch of similar products that will treat their problems. Right? I want to talk also a bit about product hopping, but I'm sort of out of time. Hopefully we can get to it during the discussion, because that's another version of how things are misjudged. So I'll stop here.
Well, thank you very, very much to our panelists. And so we wanted to open it up and give time for the audience to ask questions of our panelists. So if anyone has any questions. Joshua, do you want them to step up to the mic, or? Yeah, so if you'd like to step up to the mic, there's a microphone right there. And that way everyone can hear the question.
I'm just curious, Mr. Korn, about the data range as far as years. It was sort of unclear what years you were looking at. Is this recent, are these data points recent or old?
The years you're referring to 10
As
to
far
15.
as data points, what years were you collecting it from?
It's published data that we can provide sites for.
Is it current?
Is he asking about Lee?
Is it to you or to you?
Yeah, are you-
Is that for me?
Oh,
Oh, yes.
okay.
Sorry.
Yeah, so we were very constrained by data. Oh my goodness, this is like super loud. We were very constrained by data because of the disaggregated nature of the data that we had to get. So our data range goes from 1998 to 2012, right? Which, is 10 years in the past.
That's what I thought. Well, things have changed rather dramatic
They
as
have.
far as the technology for analyzing pharmaceuticals. There's a lot more SAR, and I'm wondering how that has affected this whole analysis. Maybe SAR is sort of changing the dynamics. There's less drug testing on animals and more testing via computers these days. So they can run through a lot of permutations that they couldn't do in the old days.
Yeah, and nothing would please us more than to be able to go back to the data provider whose corporate identity has changed and get another 10 years worth of data. That we are trying, but that is proving to be pretty difficult at prices that we can afford. We got the data from Midas back when it was IMS, and we got that through a personal connection between my co-author and the head of IMS Midas. That personal connection is gone, and I think it might be a while before we can do the kind of updating that we'd love to do.
Okay.
And I'll just chime in too, and maybe David can speak to this. But even though we have had some changes and improvements in technology that have reduced certain aspects of the research cost, we've also seen other parts of the research costs expand. So we're seeing more and longer clinical trials for some of these drugs because they're drugs that are used for chronic treatments, or they're as David mentioned, we now have a lot of these phase 4 post-marketing studies that are being required. And then, of course, with biologics, the dynamics are very different as well.
I've got a couple of questions also for Professor Branstetter. The first one has to do with, and I'm not going to complain about the data. It is what it is. But in focusing on the 2-digit ATC level of disaggregation, does that perhaps introduce a bias in the results? In other contexts, there has been this academic economics controversy about how concentration is measured in the economy. And one of the important points being made is that the level of aggregation is too great, that if you looked at relevant antitrust markets, the picture is entirely different. So first, do you think that the relevant antitrust market or the relevant market where competition occurs is smaller than that 2-digit level? And if so, do you undercount the effect on innovation? That's my first question. So hold that thought.
Sure.
Second question has to do, I don't know if you have access to any price information, but I'm wondering whether you can look at what happened to drug prices over the course of time and pre and post, the appearance of greater generic competition, because I'm wondering whether, if a patent does confer a monopoly, but the monopolist realizes that the time horizon is much shorter than expected, then maybe the harvesting of rents is going to be more intense. So that also could be greatly impacting consumer welfare. So just your thoughts on those two.
Yeah, again, really, really great questions. So we would love to be able to do a more disaggregated analysis. We'd like to be able to go down to ATC3 or ATC4, if for no other reason than just as a robustness check. But again, we're constrained by the data. So the way that the pharma projects data are constructed and the way that sort of an ATC number is assigned to these therapies, if we're looking at compounds that are in the preclinical or phase 1 clinical trials, there are a number of these compounds for which they don't know exactly what ATC4 or which of many potential ATC4 digits the thing will eventually get slotted into once it gets closer to market. We do have data that are pretty consistently recorded at the ATC 2-digit level, so that market definition is a function of a data constraint, not our preference. But it is possible that the market definition is too broad. We're actually under-measuring the impact of generic competition on innovation, and if we are, well, that means that the data are biasing us against the result that we find, which was already very large relative to my priors. So, when this happens to you and you're trying to publish an economics paper, it's actually a good thing, right? You've got a big result, right? The bias in the data is against you, which means you actually have a huge result that only looks big. But again, we'd love to be able to move down to a lower level of disaggregation, and just given the way the data are constructed, we just can't. We do observe prices, but we don't necessarily observe the right prices, right? What we'd really like to observe is a price, but it's a price net of any kind of rebate, right, or exchange of funds between the purchaser and the seller, and we don't observe those transactions. We observe something that's kind of like a wholesale posted price, not the final price. And so there could be all kinds of games that are being, engineered with these, transfers that we just have no way of measuring. But we do see big price declines when the generics come in, but we often find, right, that the price of the branded drug is high and rising, right? And in many cases, it actually increases when the generics come in because there's some group of patients that really want the branded drug. They don't perceive the generic to be an adequate substitute. And you do have a lot of monopoly power, I guess, quote unquote, with respect to those patients, and so prices go up. We do observe that in the price data that we have.
Actually, that was the third thing I was going to ask, but I thought I might be limited to two. So could one effect of the increased competition from generics be that there's a substitution between the patent protections and the protections from creating brand loyalty? So could there be a move toward higher investment to create brand loyalty, which in some sense is wasteful insofar as it's a substitute for patent protection?
So it could be, but if you look at the total volume of revenues that the branded, firm is getting after this generic competition arises, it falls very rapidly and very dramatically. So even if there's a subset of consumers for which you can raise prices, your, total net revenues for that drug are collapsing. It can be a pretty significant loss for a firm.
Also, can I just add this, that obviously I think Lee's right that overall the income to the farmer falls, and like I said before, like I don't care, right? Again, I only care about pharma only insofar as they provide goods. But I think what's right. No, I don't think any of us care. Like we only care about them insofar as like they give us something good, right? If drugs were falling on us like manna from heaven, like who cares? But I think something inherent in your question is that is it wasteful to develop this brand loyalty as opposed to patent loyalty? I think I have to take a little bit of an issue with the premise of the question, because wasteful to whom, right? So obviously some consumers, for whatever reason, maybe because they may be some issues with the way not the active ingredients developed or whatever else in generic they prefer, or some prefer just because they know the drug or because they're just so used to it. But for whatever reason, they want to stay with the brand name, and for them, for that particular consumer, that increases their welfare, and they can serve and they can choose whether or not to pay the price. I'm just worried that if we have some sort of one-size-fits-all policy saying like, no, this is wasteful and we should really tinker with our laws so as to disincentivize companies from doing that, I'm not sure that actually takes into account consumer preferences. They can express them on their own in the market.
And that's not my...
Oh.
So, hello? Good, okay. So first of all, I'd like to thank Professor Morris. This is a tremendous panel. The four of you held my attention. You talked about things way beyond my pay grade. When I was little guys tinkering, I go through the patents one by one, I do this, do that. And this gives a big picture. So it was very, very effective what you conveyed today. I do have some questions though. And I'm sorry, I don't have questions for Kevin or David because you were like the fundamentals upon which the other two speakers gave information. And those are the controversial issues. So one thing that came to mind when Professor Branstetter, you were speaking about your model was, boy, this is awfully mathematical. But the other thing was that you're talking about less of an incentive in the small molecules area because the money's in the biosimilars because they're harder for people to compete with you once you develop them. Well, on the electrical side, people talk about things of low value. They talk about a fall off in innovation and a decrease in the number of patents or companies formed that work in that field. And contrary to what Gary just told us, which was that there's been tremendous breakthroughs in small molecules research and development, it would seem like that you would expect there would be a decrease in the fundamental research into the tools used in small molecules research and development because there's less money there. And so I'm wondering, first of all, of research on that issue fall off in an area that's become undervalued because of the political winds and the existing infrastructure, legal infrastructure. And if you've seen any data along those lines or any publications that back up the thesis that you have in the sense that there's less going on, less patents produced in the analytical areas that are used to develop small molecules. So that's the main question, right? That's really I'm looking for. And like I said, what Gary said, this is Gary over here, Gary Posner, was that he's seen rapid advances, big changes.
Yeah.
Yeah. Is that a micro view from just you or a generic market view of all the players in the industry?
Well, I used to work for the federal government, so I saw what was happening with, I don't know if you guys know what SAR is. It's basically you use computers to basically sort of feel out a particular molecular structure. And the reason why small molecules are more conducive to this kind of technology is because it's easier to model a small molecule. Once you get into the larger models, it's really, really difficult. You have too many factors to deal with, so there's some uncertainty. So you have to move on to the animal studies because you really can't count on these models. They're just too complex.
Okay, before you answer, just another issue with Professor Dolin regarding your thesis. In the same vein, is that something that you've pushed towards the legislators or the administrative bodies in the policymaking area, as opposed to just being the academic? Is that a concept that they should focus on the effect on consumers specifically, in the big picture, as opposed to the way they currently do business according to you? So those are my questions.
Why don't you go first?
All right. So, it has to, I guess, of necessity almost has to be something that the executive branch has to believe that this is about, has to be consumer specific, and to some extent judicial branch. Because, obviously I'm exaggerating a little bit, but not by much, when I say if you look at our antitrust law, basically it says, don't do bad anti-competitive things, full stop. That is the entirety of the US antitrust legislation, right? It's a bit more than that, but not by much. And really a lot of antitrust law is developed basically by common law and by litigation. And so that's why Supreme Courts have ultimately went to to Judge Bork's view. So I think everything depends on how the executive views it. One of the other hats that I wear, in addition to being a law professor, I'm also a litigator for the New Civil Liberties Alliance, where we just generally take a very skeptical view of administrative state as a whole. So so ideally, from that perspective, and I believe it also as an academic, that existence of these independent agencies like FTC that are not accountable to the president, that are do not necessarily have to carry out the president's view of the proper role of antitrust law, is itself problematic. And that's why we sometimes end up with having FTC going against DOJ in court, which is weird and bizarre. So I think if the president believes in protecting consumer welfare, we'll be fine, right? But with this multiple agencies like DOJ and FTC doing their own things, it's a bit problematic.
Yeah, so to address your question, my son who studies Latin tells me that it's ceteris paribus, not ceteris paribus, right? Yeah, certainly, there were the beginnings of it, by 2012, but certainly since 2012, lots of, interesting application of, machine learning, artificial intelligence, and a bunch of other tools to the early stages of drug discovery that have generated a bit of a boost or a boomlet in small molecule-oriented startups and in that activity, right? Definitely. My argument is that, yes, we've had this, right? And yes, it's created more opportunity for smaller molecule drugs, But given that, right, we might have seen even more investment in this space if the regulatory playing field had not, as I have suggested, kind of tilted, kind of strongly in the direction of protecting biologics, but to some extent deprotecting small molecules, right? So if you think that what's happening is a good thing, right, we might see even more of it. Now, for me to sort of substantiate this ceteris paribus argument, I would need to control for a lot of things that I haven't controlled for and have more recent data that I don't yet have, right? Try and adjust for the impact of this stuff. And I'm not, able to do that. But I think, the general thrust of your question is probably right on. Yeah, this stuff is happening. That being said, I think we would have seen even more of it if we hadn't seen this drift in the parameters of our regulatory regime. But at the end of the day, can I prove that this drift is a bad thing for social welfare? That's really, really hard. And I can't. Not if the usual evidentiary standard of innocent until proven bad is applied.
But I guess I would also add that, I would also add this, that, perhaps moving towards biologics is a good thing, right? They're more, they can be more targeted, they can be more individualized, et cetera. The problem, in some sense, is not just moving away from, small molecules or chemical compounds. I think the problem is also that once we do move in that direction, and once I think medicine becomes more biologic-centered, we're gonna, I suspect, unless we kind of address it here and now, we're gonna see this dynamic that we're now facing with chemical drugs move along to biologic. There's gonna be clamoring to reduce the exclusivity period, the non-patent exclusivity period in biologics. They're going to be clamoring to allow more generic entry, and everything is going to simply replay itself unless you kind of take a particular view as to what is it we're trying to accomplish, right? And I don't think it's more competitors.
And just in response to, so that the counter argument, right, is that we're seeing a decrease in small molecule drug development because most of the...
I was asking whether we were, not making a statement that we are, because I don't know. It just seems logical that's a logical conclusion, that there would be less research in an area where there's less financial reward.
Yeah, and I think we do see that, right? And I don't know if this would qualify as the fall off, but that, I've talked to a lot of people in the pharmaceutical industry and they've closed down, certain parts of their operation. So they're no longer doing psychiatric drugs, or they're no longer doing other things that they no longer see as being profitable, perhaps because of generic entry. But that also, the critics of the pharmaceutical industry would say, well, part of the reason we're seeing this decrease in small molecule drugs is because we've already attained all the low-hanging fruit, and that there really isn't that much more future, technologically speaking, in small molecule drugs. I don't know if that's true or not, but that may be something akin to the fall-off, if I understand you correctly, of what you're talking about.
No, I don't think so. I think there's always going to be room for innovation development if there's a financial reward.
Right.
I think if there's a fall-off, it's probably because there's less incentive, not because there's less things people can discover. Gary, do you agree with that? Okay, yeah, it's probably
I agree with you, but that's the counter argument, right?
Thank you all again.
I have a short question. I'll try to make it a loud question so I don't have to talk up there. It's probably more directed to my friend Kevin or to David, and that is, for those who believe that antitrust doesn't fit the pharmaceutical or biopharmaceutical sector, what fits better? What's the alternative? Just let the market run as the wild, wild west?
Well,
And I'm not suggesting that either one of you are saying antitrust does not fit. But what is the position for what's better than antitrust?
I think I don't know that I can answer that question other than by saying, if you think an antitrust problem is created by something that occurs that is an artifact of the Hatch-Waxman Act, or the Biosimilars Act, or the Medicare Act, then fix the Hatch-Waxman Act. And, the 180-day exclusivity period in the Hatch-Waxman is, I've known academic antitrust professors who've argued, well, you know, any patent settlement where the generic doesn't, the first filing generic doesn't waive its right to exclusivity is therefore anti-competitive. And that's just, it doesn't make any sense. So I guess my position I'd try to say is that, you know, if you've got a lot of antitrust principles that work like a charm here, but you've got to understand that there's institutional pressures on the plaintiffs and the enforcement agencies that are always going to work against it. You know, it's, so it's, I don't think there's anything better other than fix the real problem. Don't try to bend the antitrust laws to say, okay, now I'm going to let a jury in Texas decide how much, whether a change to the design of an invention is product hopping and therefore illegal.
Right, so I have two observations that embed two questions. The first concerns Professor Branstetter interesting study. And I would like to contribute to this debate about the level of aggregation. When you were presenting, I asked myself the same question that was asked before. Why are you looking at the 2-digit as opposed to the 3-digit or 4-digit? Because that's, you know, supposedly closer to what would be a relevant antitrust market. But then I thought that actually looking at the 2-digit may be the right answer or the right thing to do. And the reason is the following. If you go towards disaggregation, if you go in the direction of the relevant product market, in fact, what you should get is either a 0 or a negative number. There is nothing else that can happen. Either there is a negative effect on innovation or there is no effect on innovation. And then the question, interesting research question, is what would be the level? What is the estimate? But if you look at the 2-digit level, maybe you're capturing something else, which is innovation to escape competition. So somebody that actually loses revenues in a particular, you know, drug is looking for alternatives and is trying to escape competition by differentiating its product, and is differentiating its product within, you know, an area that is similar but not too close. And in that regard, then I think that your negative number is much more interesting, because at the 2-digit level, if we really have innovation to escape competition, then now we could have a positive number. Because the direct negative effect on innovation could be compensated with the extra innovation associated to the escape of competition effect, which is linked to the Aguillon et al. Literature. So that's conjecture, but I would like to hear your opinion on that. And then before I do that, then I have a comment and question for Kevin. And you know, you have been discussing activists in the States, and you have here a rule of reason. In Europe, we have a per se rule, basically, which is linked, in a sense, to activists, in the sense that if the settlement, if the payment, if the reverse payment exceeds the litigation cost or the expected litigation cost, then that triggers a presumption that there is something anti-competitive. And I think that this threshold of the litigation cost is also embedded in activists. Now, the comment, and you will see what the question is I believe that that threshold is established on both sides of the Atlantic as a result of a misreading or incorrect reading of the economics literature. There is a famous paper by Carl Shapiro that says you don't need to look at the strength of the patent. All that you need to look is at compare the level of the settlement payment with expected cost of litigation, and that's it. Now, if you read that paper carefully, if you go from the beginning of the paper to the very end, and if you get to the conclusions, and in particular you read the last 2 paragraphs in the conclusions, the author says, it would be nice to extend my model in 2 directions. One, including asymmetric information, possibly also including people having different views about the likelihood of success in litigation. Second extension that would be very interesting is to have not a single entrant, but multiple entrants. Now, some authors, including myself, have looked at the 2 extensions, and then you find that the strength of the patent matters. So the point, and this is the question, is to what extent should lawyers read papers from A to Z, from beginning to end, before, you know, considering that they understand the economics sufficiently well to base policy or law on those economic papers? And to what extent we economists should also make sure that we don't simply say it would be nice to extend the model, but we extend the model and then we say, actually, what I said before is not robust we adopt the kind of standards that Professor Branstetter, advocated before and I think that demonstrated in his work. Thank you.
Shall I go first? Okay. Well, on both sides of the Atlantic, it is economically questionable, and I would say highly questionable, to say that the expected cost of litigation has anything to do with an amount of settlement. Traditionally, it was not true. Justice Breyer and the majority proved that none of them have spent any time litigating or settling real cases. The cost of expected litigation, how much more do you have to pay your lawyer to go to trial, if you're settling on the courthouse steps? Real cases are settled by somebody saying, what is the percentage risk I'm going to lose? What is the percentage risk he's going to lose? And then I negotiate. How risk averse is he? How risk averse is she? Okay, that is not the economically realistic way in which settlements happen. So if you have a rule that says if you're beyond the expected cost of litigation, it's presumptive anti-competitive, you're making a presumption based on nothing that has to do with anti-competitiveness, in my view. And as far as Professor Shapiro and I go way back having debates, and I think he's an excellent economist and a pretty lousy lawyer. Okay, so he is constantly declaring that something is a rule of law based on economics. In the beginning, he said that the chance that the generic might win the case is therefore a property right for consumers that courts must enforce. And the first judge I was in front of to rule against that in the Cipro cases that we litigated for 10 years said, well, that's just wrong. That's not much of a legal argument. And so you can't create property rights out of the way you wish the economic analysis would turn out. So,
All right. Well, I want to thank my panelists and ask you to join me in thanking the panelists. And we'll take a quick break.